Dear students, today we are going to discuss the UN Charter and Pacific Settlement of Disputes. As you know, throughout human history, conflict has been a feature of human society. This conflict emerges from a variety of factors such as lack of resources, ideological differences, territorial disputes, and struggle for power. From ancient times to the modern times, conflicts have taken various forms like wars, revolutions, civil unrest, and acts of terrorism. The consequences of these conflicts have been devastating, impacting individuals, communities, and entire nations in various ways, like it results loss of life and suffering, displacement and refugees problem. These conflicts also led to the destruction of infrastructure and economy. These conflicts also results into human rights violations, regional and global instability. So we can say that conflicts have the profound and far-reaching consequences. Therefore, there is a need for mechanisms to prevent and resolve these conflicts, these disputes peacefully and amicably. Such mechanisms reduce the risk of violence, protect human rights, and promote sustainable peace and development. These mechanisms are known as peaceful means of settlement of disputes. Dear students, what is pacific settlement? What is peaceful resolution of disputes? Pacific settlement in international relations means the resolution of disputes among nations through the use of peaceful methods. It means the use of all methods of conflict resolution which do not involve the use of force. So, in the peaceful settlement of disputes, the parties try to resolve their disputes through various methods like negotiations, arbitration, judicial remedies, and several other such peaceful means. Now, we are going to see the importance of peaceful settlement of disputes. Dear students, the peaceful resolution of disputes is crucial in international relations for several reasons. Like peaceful resolution of disputes help in preservation of peace and security. This peaceful resolution of disputes also encourages diplomatic dialogue and negotiation between and among nations. It also promotes trust and cooperation among nations. Peaceful resolution of disputes also ensures the protection of individuals' rights and dignity. Even in times of conflict, it promotes justice and equality. By resolving disputes peacefully, nations can avoid humanitarian crises caused by these conflicts, like displacement of people, loss of life. Peaceful resolution strengthens the effectiveness and legitimacy of international institutions such as United Nations. Therefore, these methods of peaceful resolution of disputes have a potential to enhance global governance, to promote a rules-based international order. So, dear students, we can say the peaceful resolution of disputes is essential for cooperation, for maintaining stability, for protecting human rights, and for preventing conflicts that can have devastating consequences for the nations and the global community. As you know, the United Nations is an international organization founded in 1945 after the devastation of the World War II, with the core objective of maintaining international peace and security by preventing future wars, by safeguarding human rights, and by promoting development and by creating a better future. So, to maintain peace and security and to encourage peaceful settlement of disputes, the UN Charter has dedicated the whole chapter for this purpose, and this chapter is chapter 6. Chapter 6 of the UN Charter is dedicated to the peaceful settlement of disputes. This chapter outlines the principles and mechanisms that member states are encouraged to utilize in resolving conflicts without resorting to violence, without resorting to force. In chapter 6, it is Article 33 which outlines various methods which can be used for peaceful settlement of disputes by the member states. The first method is negotiation. Negotiation is a method which involves direct discussions between parties to a dispute with the objective of reaching at a mutually acceptable solution. This negotiation involves representatives from the conflicting parties who are engaging in dialogue to identify common interests, to clarify their positions, and to explore the potential compromise, potential agreement for the dispute. So, we can say that negotiation is a flexible and informal method that allows parties to maintain control over the process and outcomes. It often requires good faith, patience, and willingness to compromise from all parties involved. Negotiation can be employed in various contexts, such as diplomatic negotiations between governments, peaceful talks between varying factions, or trade negotiations between nations. Another important method of pacific settlement of disputes is inquiry. Inquiry, dear students, refer to the gathering of information and facts relevant to a dispute. It is often conducted by a neutral party or an investigative body. So, this method of inquiry involves conducting research, interviews, and fact finding missions to gather relevant information and evidence related to the dispute. So, the purpose of inquiry is to clarify issue, identify the causes of the dispute, and to provide objective analysis in order to facilitate resolution of the dispute. So these inquiries may be conducted by independent commissions, fact-finding missions, or specialized investigative bodies established by the parties involved in the dispute. The next important method of peaceful resolution of disputes is mediation. Mediation involves the intervention of a neutral third party, the mediator, to facilitate negotiations between conflicting parties and help them to reach at a mutually acceptable solution. In this method, the mediator assists parties in identifying common ground, exploring interests, and generating creative solutions. The mediator may engage in diplomacy or can have joint sessions to facilitate communication and build trust between the parties. So, this mediation is characterized by its voluntary nature, confidentiality, and focus on empowering parties to find their own solutions with the assistance of the mediator. So, mediation can be used in various contexts like uh, international conflicts, it can be used in labor disputes, it can be used in family disputes and commercial disputes or territorial disputes, etc. Their students, another method is arbitration. Arbitration involves the submission of a dispute to a neutral third party, the arbitrator, whose decision is binding on the parties. Arbitration proceedings are more formalized than negotiation or mediation, and it involves presentation of evidence, examination of witnesses, and issuance of a final award by the arbitrator. So, arbitration offers parties greater control over the process, flexibility in selecting arbitrators, and confidentiality. Arbitration awards are enforceable under international law. This arbitration is commonly used in commercial disputes, investment disputes, and international treaties or agreements that include arbitration clauses. The last method for the peaceful settlement of disputes is judicial settlement. Judicial settlement refers to the resolution of disputes through adjudication by International Court of Justice or by any tribunal, such as International Court of Justice. In this method, parties of the dispute submit their dispute to the court, present arguments and evidences, and the court then gives its judgment on the matter. So, judicial settlement provides a formalized and authoritative resolution to disputes based on interpretation and application of international law. This judicial settlement can be used in cases like disputes over territory, maritime boundaries, human rights violations, and interpretation of international treaties. Dear students, each of these methods offers unique advantages and challenges and may be more suitable depending on the nature of the dispute, the preference of the parties involved, and the specific context in which the dispute arises. The UN Charter recognizes the importance of using a combination of these methods to effectively resolve conflicts and maintain international peace and security. Besides these peaceful methods of dispute resolution, Article 34 gives power to the Security Council to investigate any dispute or situation that might lead to international conflict. The Security Council may use various means like negotiation, mediation, or inquiry to address the dispute and prevent its escalation. Then, Article 35 gives power to the Security Council to make recommendations to the parties involved in a dispute with the aim of facilitating a peaceful resolution. These recommendations may include measures to promote dialogue, mediation, or other peaceful means of settlement. Then there is Article 36 which gives power to the Secretary General to undertake mediation efforts to resolve disputes at the request of the parties involved or upon the recommendation of the Security Council. The Secretary General may utilize his good offices, appoint special representatives, or engage in other mediation activities to assist in resolving conflicts. So, dear students, Chapter 6 of the UN Charter reflects the commitment of member states to the peaceful settlement of disputes as a fundamental principle of international relations. It provides a comprehensive framework for addressing conflict through negotiation, mediation, arbitration, and judicial settlement. Dear students, this specific settlement of disputes is guided by several key principles that help to ensure fairness, legitimacy, and effectiveness in resolving conflicts peacefully. Some of the fundamental principles of this specific settlement of disputes are like sovereignty. Sovereignty refers to the principle that states have supreme authority. They have independence within their territorial boundaries. In the context of dispute resolution, sovereignty entails respect for the sovereignty of each party involved in the dispute. The Pacific settlement of disputes respects the sovereignty of states by providing them with autonomy and agency in the resolution process. It acknowledges that states have the right to determine their own fate and to participate in resolving disputes on their own terms. Another principle is consent. Consent is basically voluntary agreement. It is an approval of all parties involved in the dispute resolution process. It is essential for ensuring that decisions and outcomes are accepted and implemented by the parties. The Pacific settlement of disputes depends on the principle of consent to ensure that all parties are willingly engaged in negotiation, mediation, arbitration, or judicial settlement. So, consent reinforces the legitimacy of the process and promotes cooperation and trust among parties. Third principle is impartiality. Impartiality refers to the unbiased, neutral approach taken by the mediators, arbitrators, or adjudicators involved in the dispute resolution process. It ensures that decisions are based on fairness, objectivity, and adherence to established norms and principles. In the Pacific settlement of disputes, impartiality is crucial for maintaining the credibility and integrity of the process. Neutral third parties such as mediators, arbitrators facilitate discussions, promote dialogue, and help parties find mutually acceptable solution without favoring any particular side. Another principle is rule of law. This rule of law is the principle that allows all individuals and entities, including states, are subjected to and accountable to laws that are fairly applicable and enforced. It ensures that decisions and outcomes are consistent with established legal norms and principles. In the Pacific settlement of disputes, the rule of law provides a framework for resolving disputes based on international law, treaties, conventions, and customary practice. It promotes legal certainty, predictability, and respect for the rights and obligations of all parties involved. Non-violence is the last principle that disputes should be resolved without resorting to physical force, coercion, or aggression. This non-violence principle emphasizes the importance of finding a peaceful and non-destructive ways to address conflicts. The Pacific settlement of disputes upholds the principle of non-violence by promoting dialogue, negotiation, mediation, and other peaceful means of resolution. It seeks to prevent the escalation of conflicts into violence and to promote a culture of peace and cooperation among nations. So, dear students, these principles form the foundation of the Pacific settlement of disputes. These principles guide the conduct of parties involved and the facilitators of the dispute resolution process. By upholding these principles, the international community can work towards resolving conflicts in a fair, equitable, and sustainable manner, promoting peace, stability, and justice on a global scale. Dear students, now we are going to discuss mechanisms for Pacific settlement of disputes by the UN. The United Nations has established specific mechanisms to facilitate the peaceful settlement of disputes, like the International Court of Justice and the role of the UN Secretary General in mediation. As I told you in the earlier lecture that International Court of Justice is the principal judicial organ of the UN. The main function of this court is to settle disputes between states and to provide advisory opinion on legal questions referred to it by UN organs or by any specialized agency of the UN. Parties to a dispute generally voluntarily submit their case to the International Court of Justice either through a special agreement or by mutual consent. The court then hears arguments from both parties, looks at the evidence, and gives its own judgment based on the principles of international law. International Court of Justice judgments are binding on the parties involved and are enforceable under international law. While the International Court of Justice does not have its own enforcement mechanism, parties are expected to comply with its rulings in good faith. Another mechanism is UN Secretary General's role in mediation. The Secretary General of the United Nations plays a key role in preventing and resolving conflicts through mediation, diplomacy, and the use of his good office. The Secretary General may undertake mediation efforts at the request of the parties involved in a dispute upon the recommendation of the Security Council or on his own initiative. He may appoint special representatives or envoys to facilitate negotiations and promote dialogue between conflicting parties. The Secretary General, for example, has been involved in mediating numerous conflicts around the world, like in Syria, Yemen, Myanmar. His diplomatic efforts often complement other UN initiatives such as peacekeeping operations, humanitarian assistance, and political negotiations. These mechanisms established by the United Nations, including the International Court of Justice and the Secretary General's role in mediation, play a very crucial role in promoting the peaceful settlement of disputes, upholding international law, and maintaining peace and security at the global level. Dear students, now we are going to discuss the challenges to the Pacific settlement of disputes. The Pacific settlement of disputes faces many challenges, many limitations, which can prevent the effectiveness of peaceful resolution of disputes. Some of these challenges are like power imbalance. Power imbalance between parties involved in a dispute can hinder negotiations and compromise efforts. When one party holds significantly more political, military, or economic power than the other, it may be less inclined to engage in meaningful dialogue or make concessions. So, what would be the impact? Power imbalance can lead to unequal bargaining position. It can lead to unequal outcomes in dispute resolution processes. For example, in territorial dispute, a stronger state may use its military or economic power to coerce a weaker state into accepting unfavorable terms or concessions. Another challenge is lack of enforcement mechanism. Dispute resolution mechanisms often lack effective enforcement mechanisms to ensure compliance with agreements or decisions reached through negotiation, mediation, or arbitration. So, what would be the impact without strong enforcement mechanisms? Parties may be less, inclined to abide by their commitments or honor their obligations. So, it could lead to non compliance and the potential breakdown of agreements. For example, in cases where parties to a conflict agree to a ceasefire or a peace agreement, there may be no effective means to enforce compliance if one party violates the terms of the agreement. Another challenge is non compliance with international law. Despite the existence of international legal frameworks, existence of various treaties which are governing the conduct and behavior of states, parties involved in disputes may disregard or violate these international laws, including principles of sovereignty, human rights, and humanitarian law. Another challenge is political and ideological differences. Disputes, dear students, often arise from deep seated political, ideological, or cultural differences between parties, making it challenging to find a common ground or to reach at a mutually acceptable solution. So, these political and ideological differences can create animosity, distrust, and polarization, therefore, making it difficult to engage in constructive dialogue, in constructive compromise. For example, conflicts rooted in ethnic, religious, or ideological differences, such as Israeli-Palestinian conflict, it persists despite numerous attempts at made through negotiation and mediation to resolve it. Another challenge is external interference and influence. External actors, including the regional powers, international organizations, and non state actors, may intervene in disputes to pursue their own interests or agendas. So, this external interference further complicates resolution efforts. External interference can increase tensions, it can escalate conflicts, and undermine the autonomy and sovereignty of parties involved in disputes. For example, foreign military interventions, economic sanctions, or diplomatic pressures from external actors may increase conflicts and prolong the resolution process. Dear students, addressing these challenges requires concerted efforts by the international community to promote dialogue, build trust, and address underlying causes through diplomatic engagement, conflict prevention measures, and adherence to international law and norms. Effective dispute resolution mechanisms should prioritize inclusivity, fairness, and accountability to ensure sustainable peace and stability. So, dear students, in today's lecture, we have seen that the United Nations, through Chapter 6 of its charter and various mechanisms, underscores the importance of peaceful settlement of disputes as a cornerstone of international relations. By emphasizing on negotiation, mediation, arbitration, and judicial settlement, the UN seeks to prevent conflicts. The UN wants to protect human rights and maintain global peace and security. However, challenges such as power imbalance, lack of enforcement mechanism, non-compliance with international law, and external interference persist. So these are posing significant obstacles to effective dispute resolution. So overcoming these challenges demands effective efforts by the international community to promote dialogue, address underlying causes, and uphold principles of sovereignty, impartiality, and non-violence. Ultimately, by adhering to the principles and mechanisms outlined in Chapter 6 of the UN Charter and promoting a culture of peace and cooperation, nations can work towards a world free from the scourge of war and strife, ensuring a brighter and more prosperous future for generations to come. Thank you.